about it. Do we have the slides up? Awesome, thank you, Wilson. So if we go to the first slide here, on the next slide. So in the course of the next sort of 20 or so minutes, we're going to try and understand the scope of the public health legal authority to investigate and control disease. And it's actually quite a lot of power. Understand the legal responsibilities of schools, particularly regarding reporting, schools and workplaces, understanding data sharing regulations to ensure the protection of student and staff information. So some of the legal issues around dealing with epidemics and outbreaks and controlling diseases. So we're going to go through this, and then after the lunch break, we're going to come back and do a case study on this. All right, next slide. So really, the federal government has delegated quite a few public health powers or to the state. So in the Constitution, the 10th Amendment says that any power that's not expressly delegated to the federal government by the Constitution is reserved for the states. So the states are the main source of authority to promote the general welfare of society. They deal with food safety, sanitation, building codes, vector control, seatbelt and helmet laws. The federal government does some things around border control, some things that would cross state lines, but for the most part, each state has great power to put their own laws in these different areas, texting while driving, speed limits, all those things that kind of promote the general welfare of society. The state has most of the power. Next slide. And in California, and I think in most states, the state law establishes these local health officers. So there's a health officer for each jurisdiction. Mostly these are counties. I think there's two cities, that City of Berkeley, and I keep getting the other one wrong, Riverside, that have their own citywide health departments. And San Francisco, of course, is a city and a county together. But mostly these are counties. They have local health officers. And a lot of authority has been delegated to the city or county level, to these, particularly to the health officers. So they deal with infectious disease investigation, jail health, restaurant certification, and outbreak response. Next slide. So you've got local health officers. So it's not the director of the Department of Public Health. It's actually the health officer who holds the power and can create these directives. So these are public health officials who are on the front line, and they have powers that extend from delegations of the state police power. And so what they put out these different health orders, and they cannot extend beyond the jurisdictional boundary of that county, and they can't conflict with or impair federal or state law. There's also a health officer at the state level that can put down statewide health directives. Next slide. So what particular power do they have around infectious disease? So upon being informed, so they have this infectious disease control authority. Upon being informed by a health officer of any contagious, infectious, or communicable disease, the department may take measures as are necessary to ascertain the nature of the disease and prevent its spread. To that end, the department may, if it considers proper, take possession or control of the body of any living person or the corpse of any deceased body. So this could include examining or ordering the examination of individuals, entering onto property to inspect a potential source of disease, taking biological samples. So, demanding basically diagnostic testing, or running laboratory analysis on those samples. So that's quite a bit of power that falls under this infectious disease control authority. Next slide. And they also have this communicable disease powers under the health and safety code, a different health and safety code. So each health officer, knowing or having reason to believe that any case of the diseases made reportable by regulation of the department or any other contagious, infectious, or communicable disease. So that COVID-19 is a reportable, mandated reportable disease like TB and various others. So if the health officer believes in this disease exists or has recently existed within the territory under his or her jurisdiction, they may take measures as may be necessary to prevent the spread of the disease or occurrence of additional cases. And specifically, they can do things like work restrictions. These are where the isolation and quarantine orders come from. They can close public places or gatherings, they can close businesses, they can institute travel restrictions, and then sort of vector and animal control comes down on this. So it's the health officer that has the power to implement these orders that we're seeing lately around shelter in place, closing of different things. Next slide. Yeah, so just to repeat, the state and local health officers have authority to issue orders. Of course, these orders must be consistent with the authority granted by the legislator or the board of supervisor, who's ever overseen them. Next slide is an example of a health order in San Francisco. It's a health officer directive, and this just says that you have to self-isolate if you have diagnosed or likely to have COVID-19, and it describes what it means to self-isolate and for how long and how you have to do it. So this is not just a guideline, this is an actual mandate or an order. If you go to the next slide. So these orders either at the state level from the California Department of Public Health or the local health officer orders. So it's a misdemeanor for anyone to violate these orders. Next slide. These health officer orders can be enforced by the sheriff of a county, has the authority to enforce within the county all orders of the health officer, and then any cities that have their own police department. So this also extends the authority of the municipal peace officers within their jurisdiction. So the sheriff at the county level and the police at the city level are actually empowered to enforce these health orders. And if we just stop here for a second. So we've just talked about like how the health officers and public health departments in general actually have a lot of power to enforce law, but in quarantine and isolation orders. But what's the balance of that? Like, you know, people also have individual rights. Like, why would you or would you not want to, send the police basically if you knew someone was violating isolation and they're like, you know, at the grocery store when, you know, they've just been diagnosed with COVID-19. Like, so what, if we could just pause, maybe put in the chat, what are sort of the pros and cons of actually enforcing health officers' orders with, you know, sort of the weight of the law? Does anyone sort of think through what are the pros and cons? So you hear of someone, you know, maybe resources, of course, like the police can't, you know, how many people do we have right now under isolation and quarantine orders? If you had the police running around everyone you thought was violating them, people would get upset if not allowed into a certain location. Yeah, well, I mean, they may get upset, but, they may not have the rights. So HIPAA violation, we'll get into that. Actually, this sort of supersedes HIPAA. People will not respond to cajoling, pleading, advising. Next. So basically, maybe the first time around, you actually pick up the phone if you know someone's violating an order. So you might pick up the phone and really start with education and talking to them about why this is important. And are there barriers? Like, is it because you're at the grocery store because you need food? Is there another way that we can think of together? And I could, refer you to social services because, they exist sort of at every county. So can I refer you to social services to get over this barrier? Are there any other way? And perhaps at some point, if, an individual continues to violate, or if it's an extreme example that they're, could be infecting a lot of people, continuing to go to work at like a skilled nursing facility when they're known positive or something, you might want to bring in the authorities in that manner. But I think that you're right, it could trigger hostility that may further create problems. So we're wanting to come up between public health and the community. We want a partnership. We want people to understand and work with us. We want to use more of the carrot than the stick. But I think it's just important to know that the stick does exist, and that for the most part, when you're trying to get people to do something, you have the force of the law behind you. It's not just a recommendation, it's actually a mandate. So just to know that we don't usually use the force of the law. I think a better idea is, to work with people to understand why they may not want to do this. Is it an education reason? Do they need additional support to do what we're asking them to do? Okay, next slide. So we just want to talk about what are the schools and workplaces' legal obligations around COVID-19. And actually, Governor Newsom just signed a new law, AB 685, that expands Cal OSHA's authority to issue stop work orders, so to shut down businesses, and it expands the notice requirement in the event of a COVID-19 exposure in the workplace. So all employers and schools are mandated to provide written notice to all employees who were at the work site or the school site within the infectious period if someone is infected. And it enhances reporting requirements to local health authorities in the event of a COVID-19 outbreak in the work site. And it's sort of defined differently, as you guys have discussed, depending on the site, that site, that workplace, that school, wherever it may be, is mandated to report this to the health department within 48 hours. So the health department not only receives, so this, because this is a communicable disease and reporting is mandated, so all the labs that do the testing report all positive cases to the health department where the testing occurred. But this is another mandate where if an employer or a school knows that there's been an outbreak in positive cases, they're also mandated to report that back to the health department. So there's laws that exist currently around this, but this is just a stronger law that's coming in to take effect on January 1st. All right, next slide. So then really this, in sum, what is really the school's legal obligation for managing an outbreak? So the school has to first notify the local health department in the jurisdiction where the school or workplace is located. If there's a known or suspected outbreak, they need to share a roster of all students or workers with the health department in the jurisdiction where the workplace is located. They need to conduct contact tracing and quarantine, so case investigation, contact tracing of confirmed cases. And this can either be done by the school, the workplace, or the health department, or both of them. They have to notify all workers or students who are potentially exposed to the individuals with COVID-19, but they must, and we'll talk a lot about this, maintain confidentiality of the individual with confirmed or suspected COVID-19 when communicating that with other workers. And we're going to talk a lot about that sort of in the school context. So you need to notify everyone that an exposure has taken place, but you cannot disclose PPI, personally, what is it? Sorry, information that would help you understand exactly who that person is. PII, personally identifiable information. Okay, next slide. So FERPA, so this relates specifically to schools and the case study. So FERPA is the Family Educational Rights and Privacy Act. It's a federal law that protects the privacy of student education records. So that one cannot, so under FERPA, you can't disclose personally identifiable information from a student's education record without prior written consent, either of the parent if they're under 18 or the student if they're over 18. So that's just a blanket law. There is an exception in that law that says there's an exception for health or safety. It's a health or safety emergency exception where educational agencies and institutions, schools, can disclose personally identifiable information to the public health agency if necessary to protect the health or safety of students or other individuals, and COVID falls into this exception. So next slide. So here are just some FAQs that we got from the Department of Education around COVID-19. So their schools are constantly, it's been drilled into their head, just like Hipaa has. FERPA, like we can't disclose this information, private information around students, just like Hipaa, we can't disclose private information around our public, but this sort of supersedes that. So the question is, if a school learns that students in attendance at the school are out sick due to COVID-19, may it disclose information about the student's illness under FERPA to other students and their parents? And again, yes, if that information is not personally identified, they're not only allowed to, they're actually mandated to in the state of California. And it's interesting because there's a lot of kind of controversy. What makes something personally identifiable? So if you say, if the school puts out a letter to parents and says, okay, so, a student was positive, this student, played, was a freshman, so everyone in the freshman class or ninth grade, but they also play, the varsity basketball team. And if there's only one student that, is a freshman plays on, then that's personally identifiable. So you have to be really careful about how you let others know that they may have come in close contact with someone who tested positive, so as not to disclose that person's identity. May educational agencies and institutions disclose without consent the names, addresses, and phone numbers? That's considered directory information of absent students to the public health department, so that the health department may contact their parents in order to assess the student's illness. And yes, they can disclose just that information, but they can't link it to any non-directory information about like a pattern of absences or whether they access special ed services or anything else in their educational records. So just the name, address, and phone number. Next slide. Is an educational agency or institution required to record disclosures of private health personally identifiable information from student education records submitted to the public health department? Yes, they have to maintain a record of requests so that that's on file. Yes, we did disclose your personally identifiable information under these conditions to the health department. Next slide. So HIPAA. So HIPAA is the Health Insurance Portability and Accountability Act, and it protects private medical information. So versus this, the school records, this is HIPAA is any, private medical information. If someone knows something about, if you're a healthcare provider, can't discuss private information with someone else without your acquiescence, basically, without you allowing them to. But there are, again, some exceptions. So the law actually allows disclosure of protected health information of an individual who has been infected with or exposed to COVID-19 in a certain conditions. If the disclosure is needed to provide treatment, like if you're going, transporting a positive patient from a skilled nursing facility to a hospital, and the emergency transporters, the ambulance would need to know that information, right? If it's required by law, for example, to a public health agency that we just talked about, again, to notify a public health authority in order to prevent or control the spread of disease. Again, you can disclose it to first responders who may be at risk of infection. And if, responding to a request by a correctional institution or law enforcement official having lawful custody of an inmate or other individual who might be COVID positive. So there are exceptions to the HIPAA rules, and information about your COVID status can be disclosed to certain people and under certain conditions, if they need to know that in order to protect themselves or others. Next slide. So then there's one other aspect. This is kind of off on another tangent. So there's all these protection of private information, and then we're actually asking people, we're mandating that they either stay home. Now the quarantine guidelines have changed, so it's somewhere between 10 to 14 days for quarantine, at least 10 days for isolation. So, and these are mandated, right? And so, well, what if people, can't leave their job, or, teachers saying they can't leave schools or whatever. So there's some new laws out there, both at the federal and state level, that actually most people are covered on if they're working full time, and different laws apply to different classes of employees. So most employees fall under some kind of emergency paid sick leave act under the Family First Coronavirus Response Act, that allow them 2 weeks of paid leave if you're subject to a federal, state, or local quarantine or isolation order. If you're experiencing symptoms of COVID-19 and seeking a diagnosis, or if you're caring for an individual who's subject to a federal, state, or local quarantine or isolation order. So it provides some protection for people who need to comply with these legal orders in vis-a-vis their jobs. And if you go to the next slide, I know this was a lot of information, and we'll have the opportunity to practice and apply it in a case. But hopefully after this, you understand a little bit more about the scope of public health legal authority to investigate and control diseases, understand sort of the legal responsibilities of schools and other workplaces regarding reporting, and a little bit around data sharing regulations to ensure the protections of student and staff information or people and their private health information. And let's go through. Andrew or Alex, do you see, I'm going to look through the chat right now, anything that we need to address, or if anyone has other questions.